Welcome to the ultimate battle over who owns life itself. On one side, a global biotech giant, on the other, Indian seed companies. Grab your popcorn, the Supreme Court is about to enter the chat. So, what's the big deal with Bolgard 2? Imagine a cotton seed that's basically a tiny superhero. Monsanto engineered it with a gene from a soil bacterium, Bt, that makes the plant produce a protein toxic to specific pests, especially the pink bollworm. Their claim? This isn't just a plant, it's a patented genetic technology within the plant. It was pitched as a game changer: fewer pesticides, healthier crops, happier farmers. But as we know, not all superheroes wear capes, and sometimes, their price tag is astronomical. For years, it was a profitable partnership. Indian seed companies like Nuziveedu Seeds licensed Monsanto's tech, embedding the Bt gene into their own local cotton varieties. Everything was fine until the government stepped in, capping the maximum sale price of Bt cotton seeds. This meant the trait value, the royalty Monsanto received, also got squeezed. Nuziveedu argued, "The market rate has changed, we need a fair price." Monsanto's response was swift and brutal: "If you don't pay our agreed fee, your license is terminated." And just like that, the breakup of the decade was official, setting the stage for a legal showdown. Nuziveedu played their ultimate Uno reverse card. Section 3(j) of the Indian Patent Act. This crucial clause says you simply cannot patent plants, seeds, or biological processes for their production. Nuziveedu argued, "Look, Monsanto, once your gene is inside my seed, it is the seed. It is the plant. You can't claim ownership over life itself, especially when our law explicitly forbids it." Monsanto, of course, countered, "But it's a chemically engineered sequence. It's our brainchild, our intellectual property, distinct from the plant it inhabits." The battle lines were drawn. Was it a chemical invention or a biological entity? Just when everyone thought this was just about license fees, the Delhi High Court Division bench dropped a bombshell. They didn't just rule on the royalty dispute, they went much further, declaring Monsanto's Bt cotton patent invalid under Section 3(j). Imagine that, a multi-billion-dollar technology, a global patent, cancelled with a stroke of a pen. The court essentially told Monsanto, "Your technology falls under the Plant Varieties Act, not the Patents Act. You're in the wrong courtroom." This sent shockwaves through the global intellectual property world. Biotech companies worldwide held their breath. If this stood, what did it mean for their genetic patents? Monsanto, naturally, wasn't going to take that lying down. They immediately appealed to the Supreme Court, who effectively said, "Hold my lassie, High Court. You moved a little too fast there." The Supreme Court didn't rule on the patentability of the Bt gene itself. Instead, they focused purely on procedure. They stated, "You cannot simply cancel such a complex patent, involving cutting-edge science, without a proper, full trial, allowing all parties to present expert evidence." The patent was restored, and the case was sent back to the single judge for a comprehensive trial. The question of whether GM seeds are patentable in India remained agonizingly open. Here's where the critical lens comes in. While the Supreme Court's procedural clarity was important, did it truly solve the problem? The core question of whether biotech giants can patent engineered genes within plants under Section 3(j) was left hanging. The court essentially said, "Let's not rush the judgment, let's have a proper trial." But by doing so, it also left both innovators and the Indian seed industry in a state of prolonged uncertainty. Did we resolve the conflict, or simply hit the snooze button on a legal, economic, and ethical alarm clock?